Hello, welcome to this video on negligence. This is the first in a number of videos which are going to explain each of the constituent elements of negligence in addition to associated issues such as res est loquitur and damages, remedies and so on, and defences. So the first issue is we need to discuss duty of care. Okay, so this video is going to focus on duty of care. And so what we need to do as an overall thing is look at the elements of negligence. We need to explain the concept of duty of care, explain the makeup of duty of care, and of course we would need to be able to apply those to any problem questions. So to start us off, we need to think about what negligence is overall in order to give some context to this. Now the classic definition of negligence was given in Blythe and Birmingham Waterworks Company from 1856. And the definition for this is, for negligence, is the omission to do something which a reasonable man, guided upon those considerations would ordinarily regulate the conduct of human affairs, would do, or doing something which a prudent and reasonable man would not do. So what we're thinking is we're going to look at the bold issues, the omission to do something which a reasonable man would do. So what we're talking about there is failing to do something that a reasonable person would do, or doing something which a prudent and reasonable man would not do. So put simply, doing something a reasonable person would not do. So we'll see how this is adapted, and when we do breach of duty, we're going to look at the concept of the reasonable man. But we need to consider, where does duty of care fit in to everything for negligence? So broadly speaking, there are three elements to negligence. We've got duty of care, we've got breach of duty, and this breach must cause the damage. This video is going to focus only on duty of care. Look to the next two videos for breach of duty and damage, and of course look at defences to negligence to consider that fourth point there. So the way we're going to look at this is we're going to start with the historical development. We're going to look at the effect of Robinson and Chief Constable of West Yorkshire Police, and then the Caparo indictment three-part test. Now, of course, this isn't in chronological order. You know, the Caparo indictment three-part test came first, but hopefully it'll make sense as we go through why I've placed it below Robinson. So as we said, we're going to look at the historical development of the duty of care concept. Now, Donoghue and Stevenson is a classic case. Now, really speaking, now we're going to use it just as an authority if a manufacturer owes a duty of care to a consumer. But this was a watershed moment for really the law on negligence. In this case, the facts are classic, aren't they? So, Mrs. Donoghue's friend purchased ginger beer. The ginger beer was in an opaque bottle, so think of a brown sort of see-through bottle there. Now, Mrs. Donoghue drank some of the ginger beer. When the remaining ginger beer was poured into a glass, the decomposed remains of the snail came out of the bottle. This appalled Mrs. Donoghue, and she became ill as a result of the negligence and the sight of the snail in the ginger beer. And of course, ginger beer she'd already drunk, so she suffered from gastroenteritis as well and shock. Now, she had no direct claim against the manufacturer based on the law of contract, so there were too many claims, too many contracts in between, you know, the manufacturer and the consumer here. So Mrs. Donoghue claimed damages against the manufacturer for the resultant shock and stomach upset, and it was left to Lord Atkin to decide, is there a claim in this case? So what they decided in this case is the rule here is that you are to love thy neighbour becomes in law. You must not injure your neighbour, but also, who is my neighbour? So you must take reasonable care to avoid acts or omissions which you can reasonably foresee would injure your neighbour. So who in law is your neighbour? And the answer seems to be persons who are closely and directly affected by your act, that you ought reasonably to have them in contemplation as being so affected when I'm directing my mind to the acts or omissions which are called in question. So this is just the idea of historical development. In essence, what they developed is the neighbour test. Now, the neighbour test is it reasonably foreseeable that you're going to cause some harm with your actions? And then secondly, is the proximity, and usually that's through physical closeness or a relationship, can also include time. So before this case then, duty could only be imposed in negligence if there was a specific or existing duty of care, and these were in limited specific situations which were taken to mean things like doctors owing a duty of care to patients, like we've seen in White House and Jordan, or sports people owing a duty of care to other participants of the sport, like in Condon and Barzi. And drivers always owe a duty of care to road users and passengers and pedestrians potentially. Nettleship and Weston is our authority for that. And of course, employers owe a duty of care to employees, as in Walker and Northumberland. Now, all of these cases will be discussed as we go through these videos. But the effect of Donoghue then is widen this scope. So the neighbour principle allowed more people to claim under the tort of negligence. So that gives a bit of context in relation to duty of care, a bit of historical development, the neighbour principle being the starting point for widening the scope. But we're going to come now to the most recent test. We're going to skip Caparo for now and come back to it. And as I said earlier, you will understand why I've done it in this way. So we're going to look at the effect of Robinson and the Chief Constable of West Yorkshire Police, which is the current position in terms of applying and explaining and outlining duty of care. So a bit on the facts here. The claimant, Mrs. Robertson, suffered injuries when she was knocked over and fallen on by two police officers who were physically apprehending a suspected drug dealer while she was in close physical proximity. Now, both the trial court and the Court of Appeal held that as police officers were immune from claiming negligence in line with the existing authority, Hill and the Chief Constable of West Yorkshire Police. There was no claim, which was successful. So this case went all the way to the Supreme Court. And what we have then is this idea of the Caparo test doesn't need to be strictly applied in every case. So what the Caparo test is a three-part test, and every time we wish to establish a duty of care, it needs to satisfy all three elements. Now instead, we can move towards a more streamlined approach following Robinson. And what we can do instead is consider, is there an existing statute or precedent that outlines a duty of care? So for example, if you're injured at work, we know there's a duty on employers through the Health and Safety at Work Act 1974. If we're injured in a car accident, we know Nettleship and Weston, there is an existing precedent there which allows us to understand that a duty is owed by drivers to passengers or drivers to pedestrians potentially. So if there's an existing statute or precedent, then we follow it, and as simple as that, we have a duty of care. But sometimes it's not as simple, so we might need to look through analogy. So what we're asking there is this similar enough? So where there's an existing or analogous duty that can be applied, the courts don't need to consider the Caparo test, as such consideration has already been determined in law, and so the duty is already recognised. We can focus instead then on the arguments about breach and causing damage. Now the only time that this test will be used, or not be used rather, the Caparo test will be used instead, is when there's a new and novel duty. So the chances of you at A level getting a novel situation are very slim. Okay, you'll be looking to establish an existing precedent or duty and apply that to the question. Additionally then, public authorities are subject to the same liabilities in tort law as private individuals, which overrules this idea of Hill and the Chief Constable of West Yorkshire Police, which we're going to look at later on in this video, and the idea that police don't owe a duty of care. So the effect then is this. We've got an approach in this order. So we consider if this duty or type of duty in our problem question falls within an existing duty, or if there's a duty established by a clear analogy, so the situation is similar but not exactly the same. So you might, for example, if you know about a case where doctors owe a duty of care to patients, then you could probably use the same case for if a nurse owe a duty of care. So in the problem question, if you have a nurse, you could perhaps use an analogy there. You could also, for example, use if the case you're looking at or the scenario we're looking at has a duty where there's a boat user, so somebody's driving a boat, you might say that's similar to a road user, and so you might use that analogy to establish a duty of care. Now if the facts are new or novel, then we use the Caparo three-part test. So just to make that abundantly clear, this is the test we use for establishing a duty of care. So we use the tests from Robinson. But like I say, if in a rare instance that Caparo indictment is necessary because the facts are new or novel, then we do need to know the Caparo three-part test. Now, I've made this abundantly clear, this isn't the test we should be using, but as a law teacher, I was always nervous about not teaching enough. So I'm going to leave this in. But I will say, I'll caveat this with the fact that, in fact, you've got several cases I'm going to discuss. You can always use those cases as authorities or establishing duties anyway. So I'll leave them in. I'll discuss them with the caveat that you can use the cases, and this probably will not be used as a test for establishing a duty of care. Now, the case itself, Caparo indictment, involves investors who claimed against company auditors who come up with inaccurate records. And the court, when deciding whether there's a duty of care, will first look to see if you're using the Caparo test to see if there's a precedent, okay? And if not, then of course we use the test from here. And it's known as the Caparo three-part test or tripartite test. So this three-part test then consists of reasonably foreseeable harm. So is the harm reasonably foreseeable? Is there proximity of some description, space-time relationship, for example, between the defendant and the claimant? And finally, the court need to consider, if we're using this test, is it fair, just and reasonable to impose a duty of care on the defendant? So we're going to deal with this first element, this concept of reasonable foreseeability. What we're really saying is, the more foreseeable the harm is, the more likely a duty is to be imposed. And the opposite is also true. So the less foreseeable harm is, the less likely a duty is to be imposed. So let's bring this to life with a bit of case law. So we're going to look first of all at the case of Borehill and Young. Now, in this case, the claimant was getting off a tram in Edinburgh and heard a motorcycle go past and almost immediately have a crash. She then went to see what happened and saw the dead motorcyclist and the aftermath of the accident. She then suffered from shock from what she'd seen and claimed this caused her to miscarry. Now the question is here, did the defendant owe a duty of care as she was in a safe place and hadn't seen the accident, only the aftermath, and even that was voluntary? She went around the corner to see it. Now the court held this damage or type of damage wasn't foreseeable as she wasn't near the crash. So the claim failed. In Kent and Griffiths, however, the ambulance service were held to a duty of care to a member of the public who called 999. The victim was having an asthma attack, and when the ambulance failed to come in a reasonable time, they suffered brain injuries. Now, it was reasonably foreseeable that a person in the claimant's position, so an injured or sick person waiting for an ambulance to take them to hospital, would be further injured if the ambulance failed to arrive or took too long to arrive. So remember, we can use this case as an authority, even if we're not using the Caparo test, to go ahead and use that as an authority. So an ambulance will owe a duty of care to a member of the public who calls them. Now we've got Haley and London Electricity Board. Now in this case, the defendant had excavated a trench in the street. They took precautions for the protection of passers-by, which were sufficient for normal sighted people. But the claimant here, who was blind, suffered injury because the precautions were inadequate for him. Now the question here was, would a reasonable man have foreseen that a blind man would have walked down the street and therefore been injured if there were no barriers, for example? And it was held that the number of blind persons to go about the street was sufficient to require the defendants to have them in contemplation as being within a foreseeable area of risk, and they should have taken appropriate precautions. And note here, at the time, about 1 in 500 people was either blind or partially sighted. The second element of the Caparo test, and this is this idea of proximity between a claimant and the defendant. So are they close enough to be affected by the actions? So this could be through time, space, relationship, or indeed a voluntary assumption of a duty. So this could be geographical closeness, as road user and the car driver, for example. It could be due to a relationship between them, such as employer-employee, manufacturer-consumer, and so on. Now, one party may be relying on the other, as we mentioned, like doctor and patient, or it may be the assumption of responsibility will often fix a person with necessary proximity. So if you're taking on the care of somebody else. So we're coming back to this case of Borehill and Young. We know the injury wasn't foreseeable, but also there was no proximity. She was too far away from the accident and the aftermath, so again the claim failed on this basis. If we contrast that though to McLaughlin and O'Brien, what we're going to see is about relationship, in this case proximity through relationship. Now Mrs. McLaughlin was told of a serious accident involving her husband and children. Now she wasn't near the accident when it happened, but was told of it shortly afterwards. Now, at the hospital, she found that one of her children had died and the other was seriously ill, and her husband, who hadn't been sedated or cleaned, was very distressed and in pain. Now, she suffered shock, so a psychiatric injury, and it was decided that the duty of care was owed to her, even though there was no proximity in time and space. The proximity of relationship between her and the other victims was enough to establish a duty. Now, there are other things to consider when you're claiming for psychiatric harm. That is going to be discussed in a different video. But yeah, keep that in mind. Now, in terms of proximity, in Home Office and Dorset Yacht Company, there were detainees in the custody of prison officers here, and they've been allowed to escape and subsequently cause damage to the claimant's yachts. And the House of Lords, which then was the highest court in the land, held that the Home Office owed a duty of care to the owners of the yachts because the prison officers had brought the detainees, the Borstal boys, into the locality where the yachts were moored, and so it created a situation of danger for the or at least potential danger for the owners. As a result, then, a special relationship was found to have been created between the prison officers and the owners of the yachts. This last concept, the idea of whether it's fair, just and reasonable to impose a duty, is one for the court to consider. Now, sometimes for policy reasons, the courts are reluctant to impose a duty of care on the defendant. Now, this wasn't originally part of the neighbour principle from Lord Atkin's test from London Hugh and Stevenson, but it's often applied to the courts when it involves public authorities such as the police, for example. Now, there are several reasons for this. You may look to impose a burden on the defendant, avoid imposing a burden, on the defendant. What that means is we're not putting too much of a burden, so for example, financial strain. If the police were under such financial strain, that would weaken the quality of the service that they offer, and as for a public policy reason, may stop that from happening. They may also stop the floodgates opening to litigation, so this means too many claims of the same nature. So they're the two main reasons we might not impose a duty of care on the defendant. Now, this is best illustrated then through Hill and the Chief Constable of West Yorkshire Police. What you can see here is this is Peter Sutcliffe, the Yorkshire Ripper. Now, the House of Lords in this case refused to impose liability on the police to the mother of the Yorkshire Ripper's last victim. After the killer had been interviewed and released by the police, they then went on to kill again. And the reason for this was a public policy argument. In essence, the court was very reluctant to say there's a duty of care owed to potential victims of crime and their families, because that would open the floodgates to too many claims and it would impose a burden on the police, which was unfair to do. However, this isn't always the case for public bodies, and as we know from Robinson anyway, that isn't the position. We need to prove if there's a duty anyway, we can prove it. But with Capital Counties plc in Hampshire County Council, a fireman here ordered the sprinkler system to be turned off in the burning building. Now, a duty was imposed here because of his positive actions made the situation worse, so it was fair, just and reasonable to impose a duty of care. This isn't going to impose a massive burden on the fire service, and it certainly isn't going to open too many claims in this case, so floodgates argument won't be satisfied either. Now, in Osmond and Ferguson, here a teacher formed a dangerous obsession for a pupil that he taught. Now, he followed him, he daubed graffiti on his house, he rammed the family car, and eventually shot and killed the boy's dad. Now, the court refused to allow a negligence case against the police, who were aware of the defendant's actions, but the European Court of Human Rights said that the blanket protection of the public services was a breach of their human rights. In essence, there could be no fair trial if the outcome is preordained. So if you sue the police, then there's no fair trial if they will never owe a duty of care. So this led to some doubt. As we know, Robinson overturned this notion that the police can never be liable anyway, or owe a duty anyway. Now we're going to look at some different cases. So MPC, the Metropolitan Police Commissioner, and Reeves, the police took a man into custody here, knowing it was known to be a risk of suicide. Now, whilst in custody, he hanged himself. Now, the police did owe a duty of care in this case because it was fair and just and reasonable to impose one. They knew about the risk and should have guarded against it, so there was a duty of care there. But if they don't know, then it will be different. So in Orange and the Chief Constable of West Yorkshire, the obligation to take care to prevent a prisoner from taking his own life only arises where the custodian knows or ought to know about that risk. So we can contrast Reeves and Orange. Now in Valino, a prisoner tried to escape, and the decision in this case was that a duty of care isn't owed to a prisoner who is injured whilst trying to escape. So this is a policy decision because of course a criminal offence is being committed, and because an escaping prisoner is no longer under control of the police. Now, a bit of a random case. We've got Mitchell and Glasgow County Council. In this case, the housing authority summoned the tenant to a meeting as he'd been abusing and threatening a neighbour. Now, at the meeting, he was told he could face eviction if his behaviour didn't improve. Now, the tenant left the meeting and killed the neighbour within an hour because obviously he had complained against him. Now, it was decided by the House of Lords it wasn't fair, just and reasonable that the authority should have had to warn a neighbour that the meeting had been arranged. There was a public policy argument as well about the floodgates argument. Would there be many claims against private landlords and social workers, for example? So it was a floodgate argument. The court were very reluctant to impose a duty in this case. So I just want to point out that all those cases we just discussed, they can serve as precedents, if you like, because you can, of course, follow the duty from each situation. The chances are, though, it's very unlikely in an exam you're going to use the Caparo 3-part test, and you're not generally expected to understand where a situation is novel. You need to understand that concept, and of course this could form the basis of a multi-choice question, for example, but the chances are you'll use the test from Robinson to establish a duty of care. Now, you will lose marks if you don't use the case at all, okay? Even if it was hypothetically a new and novel situation, you would still need to use Robinson and then Caparo. You can't just choose to use Caparo. The principle is now well established. We're 4 years in at the time of recording, and so we should make sure we've got the most up-to-date law now. So that's it. That's what we covered. We've covered the historical developments. We've said that we need to look at Robinson as the authority and how to apply a duty of care. But if in doubt, or in those rare situations, then we might need to look at Caparo 3-part test. So of course we discussed all of those factors. And of course the next video is going to focus on the breach of duty. So once we've established that duty of care, how do we prove that the person has fallen below the standard expected? So that's in the next video on breach of duty. Thanks for watching.